Trustees commonly face claims for breach of trust, misappropriation of trust funds, mismanagement, malfeasance, fraud, or breach of fiduciary duty. If you've been accused of breaching your fiduciary duties or misappropriating trust funds, contact an experienced trust litigation attorney as soon as possible. The sooner you begin working with a trust litigation attorney, the better your odds of protecting yourself. Here's a quick guide. What is breach of trust? Breach of trust refers to any type of intentional or negligent, self-serving, erroneous, or retaliatory conduct committed by the trustee of a trust that results in harm to trust assets or its beneficiaries. Misappropriation is a broad term encompassing many different types of offenses, both intentional and unintentional. Trustees have many duties under the law, and failing to live up to any of them may provide grounds for a beneficiary to file a lawsuit against you and remove you. What is an example of breach of trust? A common example of trustee negligence is that of a trustee who fails to make distributions to beneficiaries. Or perhaps you failed to properly invest trust assets, protect assets from loss, insure trust assets, or you failed to follow trust terms. Maybe you failed to take appropriate legal or financial action when trust assets were threatened. In all these cases, you could have exposure to being removed or being surcharged for the losses caused. What are a trustee's duties and responsibilities? A trustee's duty is to act in the best interest of the trust and its beneficiaries. A trustee is a person nominated in a trust document to manage assets owned by another person or their estate according to the trust's terms and the law. Here's a simplified list of a trustee's basic duties and responsibilities. 1. Administer the trust as stated. 2. Act in the best interest of the trust and its beneficiaries. 3. Treat all beneficiaries fairly and impartially. 4. The trustee may not use the trust for his or her own profit. 5. Keep trust property separate from their own property. 6. Take reasonable steps to enforce claims that affect the trust. 7. Take reasonable steps to defend actions that could result in loss to the trust. What if I'm accused of breach of trust? Contact a trust litigation attorney the moment you're accused of breaching your duties. Generally, the consultation will be free, like it is at RMO. We work with trustees like you every day and assure you it's common for well-intentioned trustees to be accused of breaching their fiduciary duties, misappropriating assets, etc., especially when the value of the trust estate is significant or there's simply family disharmony. Is there a statute of limitations on breach of trust? While the statute of limitations for contesting a trust is 120 days, the statute of limitations for breach of trust, misappropriation, malfeasance, breach of fiduciary duty, could be years, depending on your state and the specific facts and circumstances of your case. Can a trustee be sued? Yes. A trustee can be sued for a wide variety of reasons because a trustee is held to the highest legal standard, a fiduciary standard. At RMO, we generally see trustees being sued for things like failing to account, accounting irregularities, mismanagement of trust property, embezzlement, fraud, and commingling funds. Perhaps the single biggest reason trustees get sued is because they fail to keep beneficiaries informed. To defend yourself against these claims, working with an experienced trust litigation lawyer familiar with the local probate courts is crucial. Why? Because courts tend to look unfavorably upon trustees who are abusing their position, and working with a local trust litigation attorney respected by the courts will help you navigate those waters. Who pays the legal fees when a trustee is accused of breach of trust? Generally, the trust will pay the legal fees. A trustee can allocate a trust reserve, which is a reasonable amount of money or assets intended to pay debts, creditors, including legal fees in defense of the trust. When can a trustee be sued for misappropriation, negligence, mismanagement, fraud, or malfeasance? There are a variety of reasons and times where claims may be brought against a trustee. Here are some of the most common reasons. 1. When a trustee is embezzling or stealing trust assets. 2. When a trustee is personally benefiting from trust assets via fraud, forgery, or coercion. 3. When a trustee is commingling personal funds with trust funds. 4. When a trustee is making suspicious or inappropriate gifts from the trust. 5. when a trustee is subjecting trust assets to unreasonable risk. 6, when a trustee is not complying with the trust's accounting, investing, or distribution directives. 7, when a trustee is no longer of sound enough mind or ability to perform their duties competently. What is the penalty for misappropriating trust funds? Generally, an offending trustee will be removed, replaced, and/or surcharged in order to pay for the losses that you caused. Courts generally will seek to put the damaged beneficiaries back in the place they would have been but for the trustee's error, meaning the court will look to ensure the trust funds provide what the trustor intended, even if personal funds of a trustee who is in breach are required to make the beneficiaries whole. When should I contact a trust litigation attorney? The simple answer is that you should contact a trust litigation attorney the moment you suspect a claim may be filed against you. In any case, realize that you have nothing to lose by getting a free consultation. At RMO, our consultations are always free because we want to hear all the facts of your case and make sure we're in a position to help you. We protect trustees like you every day. Like I said, the consultation's always free. Shoot us an email, give us a call. We're always happy to help. Thanks for watching.